Good morning, Mr. Goldman.
Good morning. I'm Rich Goldman. I represent Brandon Watson. And I'd just like to acknowledge the amicus brief that was filed by David Siegel and the New England Innocent Project, and I trust the Court will find that useful. May it please the Court, this case arises from a shooting that occurred in Springfield on the night of May 11th, May 12th, 2006. The victim, who was the eyewitness, testified that there were two assailants. He knew the first person, who was the shooter, from past experience and identified him through that past experience. The second person involved he did not know, had never seen him, testified that he'd never seen him before, and made the identification of that person from a photographic array that was presented to him by a Springfield detective. And the issue of that photo array and the suggestiveness of it is at the crux of this appeal.
Well, what do you say the police should do when they're giving a witness an array? Should they say to them, well, maybe the suspect is in this array and maybe not? I mean, what do they say?
Right. As Your Honor knows, the guidelines, protocols that have been developed, and this Court recently visited and addressed in Santiago, and what they should definitely say is that I'm going to show you a series of photos. The perpetrator, the suspect, whatever they want to say, may or may not be included. If you don't pick anyone out, the investigation will continue. But they should not say, as what happened as they did in this case, that the person we found. What happened was the detective told the witness, we found that I think we've identified the second suspect. He's in this group of 8 photos.
Is it clear that that's what the victim was told?
Essentially,
That's
yes.
what the judge found.
There-
Yes.
That's
yes.
clear.
And
Okay.
there was
And the record supports that.
Yes, at both the motion. The detective first testified. There was a motion. There was a motion to suppress Dugan hearing. The detective first testified that he did not say that.
Right.
But on cross-examination, he admitted he did. Same thing at the trial. At trial, he first said I would never say that to a witness. Although, again, he might have said the expression here. But then he admitted that he did in cross-examination. He was confronted with.
But just on that point, because I wasn't clear from this record, I understand that certainly the judge found, and you say in your brief, that with respect to the identification at the hospital, absolutely. What about the morning after? Did he repeat? The judge found that he repeated it, but I'm not sure that the record supports that.
Yeah, I'm not sure. I don't believe. I think the testimony was that he said it at the hospital, but
Right.
not at the house the next day.
Okay, so
But
the
what
judge's findings weren't quite right on that point.
But what came out at the house the next day, in terms of what the detective said,
Yeah,
but
right.
what the eyewitness said was, his testimony was that, well, again, this is at the trial, he did not testify at the motion hearing. Well, that's the picture I picked out the first time. So in making so even though the detective didn't make that statement at the house, the argument is that that taint from the initial, the Commonwealth can't show by clear and convincing evidence that the subsequent identification was independent of the first.
The judge found that he said, that the police officer said that he believed there was a second suspect. Is that right?
They had a second suspect.
Right, that they had. Right.
Okay, they had a second suspect. But, of course, if someone is shown an array, I mean, why would they be shown an array if there isn't somebody whom the police are considering?
Right. Well,
Or some people?
Right. Well, I think this Court's cases and acknowledge that, and as Your Honor suggests, but the difference is the suggestion, for example, the cases that talk about where a witness may have overheard on the radio police transmission that they might be going to view a suspect, or that the police are taking someone to view someone and show up in a situation that resembles an identification. That is one situation where this Court has found in those situations that it's not unduly suggestive. But when you have a detective saying outright, and this comes after, this was not the initial contact with the witness. So the detective first met the witness in the emergency room shortly after the shooting, had brief discussion, but met with him again still that same day, the same morning at 9:00 a.m., where he had a longer discussion with the witness, where they went over, addressed the police investigation and certain evidence that had been recovered, and so basically validating what the witness, and discussing the ongoing police investigation, is giving the witness more reason to believe him as the relationship
But he isn't
goes
telling him
on.
who it is. I mean,
He
you
didn't-
wouldn't show somebody an array of just people, if the incident happened in Pittsfield, you wouldn't show people from Boston. I mean, you're going to show people who logically you suspect.
Mm-hmm.
So if the police officer doesn't give any clue as to who it is, what is the police officer, how is the police officer guiding the victim in any way?
Well, it may not necessarily guide the victim to a specific person in the array, but it transforms what might be an objective look at photos
haven't
to
we-
a
That's why I'm
relative.
saying,
Haven't we resolved this in Silver again, in Silver Santiago? We said what the police officer should say, the alleged wrongdoer may or may not be in the photographs depicted. It is just as important to clear a person from suspicion as to identify a person as the wrongdoer. Individuals depicted, I mean, you're
Right.
telling them, we don't know if the right person is in here.
Right.
Given that that's what we said in Silva Santiago, which is May of 2009, do you think maybe that we need to give time? I mean, are you saying, quite apart from Silva Santiago, I take it what you're saying is, quite apart from what we said in Silva Santiago, this, because of what he did, it was by any stretch impermissibly suggested. And whether it did or didn't conform with the DOJ guidelines, it's impermissibly suggested. That's your point?
Yes. Yes. And that, to follow up, it's not too soon, because I think what this case is a natural extension of what the court held in Silva Santiago, that more than just an advisement to the police, to law enforcement, to give these instructions is needed. Because not to suggest that police are acting out of malicious motive or bad intent, they're trying to solve crimes, but they're motivated to, it's when they're motivated to solve a crime that there might be this undue suggestion that arises in a photo ID. By, again, either not giving the instructions that this court suggested in Silva Santiago, or what happened in this case, going the next step and saying, here's 8 pictures, pick the guy out. And so...
But it's a peculiar problem because in the cases where it has subsequently been determined, even after close appellate scrutiny, that somebody in fact did not commit the crime, one of the biggest areas, if not the biggest area, appears to be eyewitness identification. So there's a particular interest in making sure that based on known studies of what tends to influence people, understandably, for the reasons that Justice Cowan suggests. I mean, anybody going into a police station is going to assume that for whatever reason the police, acting in good faith, have got the guy, and they're putting his photograph in the array. That's an enormous weight on how people view pictures. So unless you give some counteracting instruction, you may in fact have an erroneous identification.
Correct. And that's why this case presents, I think, all the right...
Let me ask you this. In this case, did the victim independently ID the defendant at trial?
There were these subsequent identifications were at his house the following morning and then at the trial, and those both came into evidence at trial. And it's our
But
position...
you say it's all tainted by
Right.
the
Well, in
first...
fact, there have been repeated cases of innocence which show that, in fact, what happens is you get a confirming process.
Right. And that's, as I mentioned in the amicus brief, and I tried to point out in my brief, the studies that have been done and the development of the field in behavioral psychology that shows that that in all kinds of areas that witnesses, that the subsequent identifications are based on just confirming the initial investigation.
I take it in this case, there was a substantial cross-examination on just those points. It wasn't that the defense counsel was not aware of the fact that there are better procedures that seem to have produced better results, and cross-examined the officer extensively on the fact that the officer was not familiar with them and didn't do them and all this kind of stuff.
Right. And that's why there was. And that's why I think that this case cries out for further action by this court, because within the framework that he had...
Is that because the jury came out the wrong way that it cries out for further action, or is it because that wasn't sufficient?
Because it's not, because the jury, there's not enough guidance to the jury, because the jury had cross-examination, right.
Was there a
So that
jury
the-
instruction here?
I'm sorry?
There's a Presley
There's a-
instruction.
Right, honest but mistaken instructions. But that, again, that doesn't go far enough, I would argue, because what that does, it tells the jury, okay, somebody might, either the witness is trying to make an identification, but made a mistake, but trying to do the best. But it doesn't go into the factors that all the behavioral psychology studies that have shown go into the identification itself. So, and in addition, the honest and mistaken instruction goes into, essentially it's talking about reliability to some extent, which is not really a determination of the, as this court has noted, under Article 12, the due process right to that.
Yes, but
and I know there's a
ultimately,
little
I agree with you, that goes to suppression or not, but it is ultimately what matters is whether it's a reliable identification. I'm not saying for suppression purposes, but when you're talking to the jury, that's what matters.
Right. When you get to that point, and I would argue this case should never have gotten to that point, that the motion judge erred in denying the motion to suppress. But to get back to your question, Justice Cordy, about the cross-examination, again, I think that the lawyer did what he could to bring that out to the jury. But the detective said, in response, said, no, I'm not aware of the studies. No, I wasn't trained to follow about the DOJ guidelines. So what was left was there was no substantive evidence about what those guidelines, what those studies were. There was just the defense lawyer then arguing in summation, or attempting to argue in summation, that these things should be followed, but it wasn't evidence, and the judge then instructs the jury that arguments of counsel are not evidence. So the framework of the law as it exists now is just simply not sufficient to protect against the risk of a misidentification, which is increased when the eyewitness does not know the.
And your view is that counsel was essentially ineffective for not arranging for an expert to come and testify, for example, as to what the best procedures would be.
Right. And arguably, I know on the one hand I'm arguing that counsel did the best he could in the framework of the law, but yes, he could have done a bit more in trying to get an expert to come in and
What do
testify.
you do about the fact that he thought, and I think the judge said reasonably thought, that his client didn't qualify for indigency, but also was saying, I'm not coming up with the money. What could he do?
That's problematic, which again is why I think relief from this court or action by this court in terms of when you have situations, and again, this is a narrow framework of cases where the police fail to follow these specific protocols set up by this court in Silva Santiago, that then at the defendant's election, there could either be, or both, a jury instruction telling the jury that the risk of misidentification is increased because of the police action in the identification procedure, or expert testimony at the defendant's election to explain to the jury, to educate the jury on the process of eyewitness identification, which this court, again, in Silva Santiago noted the difference, I think, one difference between this case and Silva Santiago is, as the court noted in that case, there was an expert, and that expert enabled the jury to reasonably assess the eyewitness evidence as it came in, which wasn't the case in this.
Could I ask you this question? Do you think that, one of your suggestions or your arguments, it's more than a suggestion, is that there should be instructions about what should have happened, and you can reasonably take into account that it didn't in weighing the identification? If such an instruction gets tied to the DOJ guidelines, for example, as there's more psychological studies of investigation technique and how the brain reacts, in other words, are you? I guess my question is, are you cementing and freezing a particular format, which has its own risks as life moves on?
Well, I guess this court has recognized through, over time, the development in the law of, just sticking here on eyewitness identification, and moved with it as well for cross-racial identifications or other instances. So I wonder if it would, I guess maybe it wouldn't cement the court, because the court is then able to adjust to, if you say for example, that in instances like this where the police fail to give adequate cautionary instructions before they show a photo array or conduct an identification procedure, that those measures are required. It wouldn't prevent the court from then expanding that if the field of behavioral psychology went further to establish further cemented rules or guidelines that then could be followed. So it would be, I think, applicable now to what the field is showing is necessary, but the court could then move beyond if necessary when the evidence supported it.
Thank you, Mr. Goldman.
Thank you.
Good morning, Your Honors.
Good
Diane
morning, Ms.
Dillon, an
Dillon.
Assistant District Attorney representing Camden County. It was just in May that this court came down with the Silva-Santiago decision, and in that decision, you noted that you have never held that these factors raised by the defendant in this case have been the cause for reversal when a determination is made about whether something is unnecessarily suggestive. But you suggested that in the future, a protocol should be in place, and you went so far as to say that in other cases, for instance, D. Giambattista, when police didn't take your advice about things that should happen in the future, you come down with a rule. Well, the judge heard this case in 2007, 2 years before Silva-Santiago, and he applied the law that was in effect at the time. And it's not really different from the law that was espoused by you in May, because then on page 797 you said the question is not whether or not it's suggestive, it's whether it's unnecessarily suggestive. And the law since 1967 has been very strict. It's whether there's a very substantial likelihood, not risk, of irreparable misidentification, and that did not happen in this case.
Ms. Dillon, could you address the defendant's claim in his reply brief that you have left out a critical piece in reciting the fact of defendant Rodriguez's testimony, namely that he told the witness that the suspect's picture was included in the photo array?
I take issue with that criticism. I can understand why it's confusing. They keep talking about 2 identifications. In fact, there are 3 identifications. The testimony is somewhat confusing. The officer was sure that he did not tell him.
The judge found that he did.
He did find that he
So
did.
isn't that's binding on us?
That's what we have to deal with, that the judge found
That's
it,
my
but
point
that
was
doesn't mean that the record.
why was that not included in your recitation of the findings? I mean, we're looking at the findings.
Well, the findings are there in the brief. I didn't feel it necessary to replicate them verbatim since I appended them.
No, not verbatim, but in any case, it was a point that I mean, that's the critical piece that is really at issue here, isn't it? I mean, that's the
Whether or not he told them that there was a suspect.
No, but that is what goes to the heart of whether it is unnecessarily suggestive.
If you look at the cases, for instance, Phillips or Leonardi or Napolitano, or in those cases I think were cited in Silva-Santiago, it's just jurors or people tend to assume, I'm going to show you an array, we have a suspect. And he never said which was the suspect. And in fact, there was testimony at trial, not in the motion, from the victim who said, he told me not to feel pressured, that he'd come back with other photographs if he wasn't there.
The second time. Right.
The second time,
in the morning,
not
in
at the hospital.
Right. But he also said something to the effect of, that was the picture I'd picked out the night before.
He did. Well, it was the same picture.
Right. But I mean,
But he said that was the second suspect. He didn't say, I'm picking that out because that's the picture that I saw the night before. I mean, it's a little bit incongruous to say he was so groggy the night at the hospital that he didn't know what he was doing, and then to suggest the next morning, some 12 hours later, he could say that's the same suspect if there wasn't something else going on. Now, the judge did make findings about the source of this in his findings on the denial of the motion for new trial. The hearing that was held in May, having to do with the identification, just had to do with whether or not it was unnecessarily suggestive. And the judge found that it was not, and this record does support
Would
his
you agree it
findings.
was suggestive?
I think it could have been handled better, sure. And
So the question is whether it was so suggestive as to be unduly suggestive.
that is the legal standard that the judge was obliged to apply. In this case, another difference is there was corroborating evidence in this case.
What was it?
Well, he also identified the two cars that were found immediately. There was Mr. King, who identified, saw what was happening, followed it to the co-defendant's house. That's where the other car was found. Also found at that scene were the cell phones that were taken from the victim, the bloody $5 bill, duct tape because the victim had been duct taped. Those things were found. Nearby, I'm not sure exactly where, but in the vicinity was the other vehicle used. That's the SUV with the North Carolina plates, Josiah. That was registered to the defendant, that the defendant was observed driving 1 hour before the abduction with the co-defendant as a passenger. There were all of these other corroborating factors for the jury to consider. And you have to look at the instruction that was given, too. The instruction that was asked for was given, and that was the Presley instruction, and it was a very expansive Presley instruction. You should consider these factors. You consider that. And you must scrutinize it very, very carefully. And if, after all of these instructions, you are not satisfied beyond a reasonable doubt that the Commonwealth has proved the identity of the defendant, you must acquit him. That was the instruction given, and it fits this facts. For us to reverse it now, you would have to find that there was some sort of prejudicial error, and the record doesn't support it. There was nothing more that was asked for at the time. That's what the defendant, it was a correct statement of the law. It's still a correct statement of the law. And I would go on to the other argument that if you get involved in saying there's going to be another standard instruction, because judges are free to craft additional instructions to fit the particular facts of a case, and they do so when they're requested to do so. And now we have Silva Santiago and a recognition from any number of other cases about other things that the jury might be instructed on if requested and if it fits the facts of the case. But if we just say, look, just because it doesn't conform to a study that may or may not be valid now, you're taking away the function of the jury to decide the credibility of the witnesses, which is what we instruct them that they are the sole judges of.
Well,
you are taking a...
Are you suggesting that DGM Batista takes away the function of the jury in deciding whether the defendant made or didn't make the statement that wasn't recorded?
No. In fact, I think that the videotaping assists the jury in determining whether
Isn't
or
that
not...
what Mr. Goldman's asking for, is an instruction that would just say you need to look at it, you know?
You need to look at it carefully. There's no problem with that.
Because there was this telling them that...
But then you're saying that the expert, if there was an expert, or this study that the jury may or may not be familiar with, takes away their ability to do what we tell them to do all the time, assess the credibility of the jury. And he also wants you to take away the ability of the judge to exercise his discretion as to when an expert should be allowed to testify. And we already have the factors.
What do we do with a judge who makes the statement that one reason why he's saying it was not unnecessarily suggestive the first go-around is that when he identified it the second go-around, that, quote, only bolstered the reliability of the initial identification, when in fact there have now been compelling studies to show that that may be precisely the wrong conclusion to draw?
That is not the conclusion that the judge who was familiar with those studies did draw in this case, though, Your Honor. Because also the factors that we consider in evaluating the reliability of an identification is whether or not the witness has ever misidentified someone. So the other factors concerning that. I mean, the time, we're talking about within hours of the incident. The strength, he said he was 95% sure the first time. These are factors as are set out in Santolini and some other cases. These are factors that the judge did apply. And he found that it was not unduly suggestive. And that is the finding that he made. Just as I acknowledge that, although I'm not sure the record supports, how many times he was told, the judge's findings are there, and the record does support the finding that this is very much what Concepcion, I'm not sure if I'm pronouncing it correctly. There are instances when some identifications are somewhat suggestive, but that does not mean they give rise to a violation of due process. That does not give grounds for suppression. In this case, he said in his other findings, they were together in the car for quite some time. They were face-to-face in combat. He did get a chance to look at him. And if you look at the other physical corroborating evidence, the jury were warranted in returning this verdict. And that's, after all, what we're looking at in the long run, was justice done. Now, the first argument has to do with suppression. He found it was not unnecessarily suggestive, and the facts fit that, and it fits well within the statutory scheme that was in effect in May in 2007. That's still in effect now because you've said, in the future, we want a protocol. But that is something that's going to have to be worked into based on the advice that you gave us all this past May. On this record, given everything that defense counsel did, this was not something that was taken away from the jury's consideration. It was fully explored for the jury. He did a masterful job of doing that. And I would suggest that this is very much like Bowden. As long as you don't take it away from the jury's consideration, you're not automatically entitled to an instruction that the investigation was substandard or that the identification procedures were substandard. In this case, it was aired for the jury, and there are several other cases that say, don't take this away from the jury's consideration. Let them know what the factors are. Doesn't mean you have to read the whole DOJ manual to them, but let them know what it is, air it for them, give them guidance in the instructions, what the judge did in this particular instance, and then let them decide. The idea that the very fact that a defendant is asking for an expert should remove from the judge's discretion the ability to appoint one or whatever, I think is anathema. We'd be wasting judicial resources if we set down a rule like that. The judge has guidance from this court on the factors to consider. We should leave that in place.
Can I ask you, it's not in the record, it's just a sort of practical question. Since Silva Santiago, I'm just wondering, as a district attorney's office, whether your office has communicated with the Hampden County Police Departments about the need for a protocol.
Not only that, we also have training set up, Your Honor. We've done it in the past, and we'll do it again in the future, and there's one later this month. And identification is always on the agenda.
Has anybody thought of printing a little card like the Miranda card, just so people can carry with them and say
Well,
whatever
maybe
it is
we'd
they're
have to
supposed
get
say?
something bigger than a little card, but yes, these are guidelines that we do want to discuss with them. I think it's in addition to whatever training they should have available to them in the booking room, up in the Detective Bureau, having in mind that not all departments are large enough and sophisticated enough to do this. Certainly state police help out in instances where more help is needed, but yes.
You said earlier that the strength of corroboration should be considered by us. Were you speaking to the motion for ineffective assistance, or were you speaking to the motion to suppress?
Not the motion to suppress.
Okay, so your view of the motion to suppress, I assume we should evaluate the length of time the victim saw these individuals, the length, the period of time, the clarity of his vision,
Yes.
his certainty, all those circumstances.
whether
but
or not he was
not the other
impaired.
evidence which he would not know.
No, the four factors that I perhaps put in the wrong part of my argument, have to do with whether or not a judge is going to allow for expert testimony.
All right.
These are-
And am I correct that there was never any challenge to the fairness of the spread itself, that the photos were not challenged as being unfairly pointing to one person?
Not prior to the conviction, no. The only thing that was ever mentioned was ex post facto. One of the four wearing a white shirt had a V-neck white shirt as opposed to a presumably crew neck white shirt.
Was the defendant, I think.
Was, yes. But that was not raised ahead of time. That was something that was in the post-trial.
And was there any evidence that the victim had identified the second person, the passenger, as wearing a V-neck shirt?
No.
Okay, so that was not as if that was something that had been said by the victim before the photo spread was prepared?
No, it was not a very elaborate description that was given at the time.
Just white shirt, black hair, right? Something like that.
Not much more than that, no. Not much more than that. If you have no other questions, I'll rest on my
Thank you,
brief.
Ms. Dillon.